I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning, friends and family. Hello, good morning. The good news is we are here live, hanging out, seeing each other, spending quality time together, bedhead and all. That's the good news. The bad news is I still don't know when they're going to release the video, but we'll watch it together at some point in our lives when they do. But I wanted to go live anyway, just because I love y'all. And we have a couple other things to go over. There are some new motions. Okay, so remember when we watched this the other day, aw. There's like dogs running around playing with each other on the beach. It's really cute. Squirrel. So remember the other day, Sarah Boone said that she had some filings, some motions that she wanted to turn into the judge. So she did. So we're going to take a look at those, even though we don't have her video yet. We're going to take a look at those and pull them up. Let's see. Here we go. And then we're also going to look at some information about the trial that is starting next week that we're going to be looking at after this one is over. So we have a couple things to go over. A couple things to spend our time on this morning. Where are the papers? There they are. Okay. All right. So the motion for immediate. Oops. Get it together, Brandi. Stop pressing buttons, Brandi. Let me zoom on in there. Share my screen. Share. Okay. So this is the first one that she, well, I don't know if it's the first one that she filed, but it's one of them. It's the first one we're going to look at. This one is the motion for immediate address correction. Remember she was saying that they don't have her correct mailing address and that they needed to fix it, and she was complaining about that. So this is her handwritten. What you doing? What you doing, silly girl? Bad dog stuff. So sorry, Lucy's being needy. Natalie, thank you. Happy Friday. Woo woo. It is Friday, and I'm excited. So excited. So excited. I'm going to the movies tonight. Going to dinner and a movie with one of my friends. Sleeping in tomorrow. All that fun stuff. Anywho, thank you for the super chat. I love Fridays. Oh, I turned my air off when I was recording the podcast. I was like, why is it getting hot in here? Look, y'all can tell I didn't take my medicine, huh? 80 degrees in here. I turn off the air conditioner when I'm recording because you can hear it on the podcast. What movie? We are going to see It Ends With Us. It's a book that she and I both read that we really liked. So we are going to go see the movie. And I'm excited about it. But I never liked the movies as much as the books. I love reading. And I never like the movies as much as the books. But we're going to give it a go anyway. Marie Moss, I knew you needed me back to remind you to take your... Yes, let me do that now. Let me do that now before we go any further. Because I've got so much I've got to get done today between this and the podcast and then Karen Reed and then our other trial. So much to get done today. So let me take my medicine. Otherwise, we'll never get through a sentence. Nessa, yes, I did read It Starts With Us. And what's her other one? Veracity or... Veracity? What's it called? Hold on. What was that book? Verity. That was it. Words escape me. That was it. That one was a good one too. That one was a really good one. We should do a book club stream. Who likes reading? We should do a book club stream. We talk about books. The thing is, I like different genres, and some of them I like quick reads, you know. I love those like Harlan Coben and stuff like that, where it's like the page turners, where it's all these different characters and then everything kind of starts coming together. I love stuff like that. But I also love stuff that's the stuff that's written in such a way that like just makes you want to soak up every word. I don't read romance. No, I don't read. There are some books that I have that have some romance in it, like the Colleen Hoover books. You know, they have some romance in them, but I can't do the romance books. I'm not a romance person. I'm not like I don't want you to write me poems and that's just not. I'm just not a romance person. So I don't like reading romance because I'm like, this is cheesy. It's not my thing. But I love, there are certain books that I love that are just like life-changing. The Paris Wife, have y'all ever read that one? The Paris Wife is one of the most beautifully written books. Love it. Hey, Baker. Guys, she's a catch. No flowers or holding her door. Go get her. No, you got to hold my door. That's not romance. That's manners. That one, that's a deal breaker. If every first date I've ever been on, if they don't since going through terrible relationships, if they don't open the door, I'm like, peace out, homie. Good luck to you. That's a deal breaker for me. But I don't need the romance stuff. Not a fan. High maintenance fast. Who has read, okay, who has read, we'll get into, you know what, we'll get into all this in a minute. There's always time for murder stuff, but let's talk fun stuff for a minute. Who has read The Paris Wife? Anybody? Here's what I love about The Paris Wife. If you haven't read it, I highly recommend it. Here's what I love about it. It's historical fiction. I love historical fiction. I love historical fiction. So I'll tell you some of my favorites. The Paris Wife is one of my favorites. It's based on Ernest Hemingway's first wife. And it's called The Paris Wife because the majority of their marriage, they lived in Paris. And it talks about, it's based on, I mean, it's historical fiction, but it's based on a lot of writing from, you know, journals and things like that. So it's based on reality stuff. But it brings in, it's such a cool perspective because it's like, we all know about Ernest. Well, I mean, anybody who's like, I was a English lit major before I moved over to psychology because I originally, which is why my first degree is in education, because I originally wanted to teach college literature. That was my original plan. And then I did my practicum and I hated teaching, hated it, hated everything about it. Which is why I swapped. So, but literature's always been like, that's always been it was always my favorite class. So I've always read Ernest Hemingway, know about Ernest Hemingway and stuff, but hearing the stuff about him from the perspective of, from his first wife, and again, it's historical fiction, but it's based on, you know, journals and stuff. It's just a cool way to look at things. And it talks about, you know, the meeting all of these different people who were, you know, in his life at all these different times and kind of how their worlds were revolving around each other. And like Scott Fitzgerald and Ezra Pound and all these other people. It's a really good book, but it's so beautifully written, and it kind of goes through how things were when they were in Paris and before he became a huge deal and stuff like that. It's a really, really good book. Very well written. It's one of those where every sentence that you read, you just want to soak up the words because it's so beautifully written. I highly, highly recommend that one. I love biographies too, and memoirs. I love, what is it? The glass, is it the glass house? Not the glass house. What is that? What is that? Is it the glass house? The glass, it's not the glass house. What is it? The glass castle. The glass castle. Have y'all read that one? That's a memoir. Love that one. It's my favorite of all memoirs. It's my favorite in that genre. It's another one that's incredibly, incredibly well written. I keep meaning to read The Paris Wife. Do it. Do it. You will love it. It is incredible. Most books that I read, I give them away. I donate them after. Especially here at the beach, because there's always people here who are, you know, on vacation and stuff. And so when I finish a book, you know, I'll give it to somebody here, or there's like one of those donation box things over here. I like to get rid of them. I don't like to keep a lot of stuff because my condo is so small. I don't have room for a lot of stuff. But the ones that I love, I keep because I want to read them again. And The Paris Wife and The Glass Castle are among those two. Glass Castle, they made a movie of it, and I saw the movie years later. I wasn't a fan of the movie, but the book, incredible. Incredible. I love the second Mrs. Astor. Actually, I just finished a I say just, I finished it while I was going through treatment because I would read it while I was in treatment. It's a historical book on the history of the Astor family. It was really interesting. I like history and stuff too, especially like old New York. I read fiction about Hemingway during the Spanish War. Really good. Forgot the name. Hemingway is very, very interesting. Very interesting. Oh, you got to read The Paris Wife. You've got to read The Paris Wife. So good. The Glass Menagerie. Okay, so I loved that one. Tennessee Williams, right? I love that one, but yeah, Glass Castle was the memoir that I was thinking. So good. So good. Good morning. Good morning. I'm writing these down. I haven't read a good book in a long time. Oh, I am. Oh, there's my mama. Hey, mama. FYI, you look pretty this morning. That's a stretch. Save me a lunch date this weekend. I will. Let's do lunch tomorrow. Love you, mama. I hate that books have hidden meaning. Got to tell me how it is, black and white. A lot of people say that, but I love the hidden meanings, and I love being able to, for people to be able to find their own meanings. That was one thing that I always found really interesting when I would talk to people when I was in school, in college, like talking to people about what they got out of stuff. I loved that because people can get so many different things out of stuff that they read. I love it. I love it. Hi, Brandy's mom. I just read Skid Kid, such a good book. I haven't read that one. Let's see. Hold on. Let me look at my little book thing. We're just going off the rails. Unmedicated Brandi. Unmedicated Brandi. Sometimes that's necessary. Okay. This one is another one. This one is another one. This one, Before We Were Yours, it's another historical fiction. This one is heartbreaking. I don't know if you've ever heard of Georgia Tann, but Georgia Tann and the Tennessee Children's, what's it called? Tennessee Children's Home? Hold on, let me look. Yeah, Tennessee Children's Home Society. So sad. but so incredible. And really, it's historical fiction, but it's based on stuff that was actually happening. So, and I mean, really, if you think about it in the grand scheme of things, happening not that long ago. Oh my gosh, Angela's Ashes is another one that I loved. I loved the descriptions of the poverty in New York, and that one was just another one that's like heartbreaking, but so well written. But this one is, okay, so Georgia Tan and the Tennessee Children's Home Society. This is all stuff that actually happened. This is, again, historical fiction. So these specific kids that it talks about here are not necessarily real, but all of the stuff that it's going on around them was real. It was like an orphanage where they used to sell children. And the reason I say sell children, not adopt out children, is because they would take children. They would go through the impoverished areas, like the like all over. Police were involved in it too because they were getting a payday out of it. And they would basically kidnap children, but they would do it under using the law, saying like, oh, well, your kid is out here playing alone, so you're no longer fit to be their parent. And then they would take these kids and give them to this orphanage, Georgia Tan, who people thought that she was just a hero. She was just getting all these kids' families. No, she was kidnapping them. And it was a whole business for her. And she would kidnap them, change their names, separate all the kids. There was the conditions that they lived in were terrible, and kids would just go missing. It was awful. And some of them, there are some books that were written by some of the ones who actually, like the surviving kids who actually got out and wrote books about it or whatever. But this one's a historical fiction, but it gives a lot of information about Georgia Tan. Oh my gracious alive. It is so good. So good. So sad. Oh, and then this is The Paris Wife, for anybody that wants to read that one. And then Glass Castle. Those are like 3 of my all-time tops. The title of that one, Before We Were Yours. Another good one that is it's based on a picture that was in a newspaper or something. It's called Sold on a Monday. Has anybody ever read Sold on a Monday? Hold on, let me pull up the picture. There's a real life picture, and Sold on a Monday was based on that picture. And the writer, Sold on a Monday photograph. Ah, here it is. This is it. Won't let me zoom in anymore. Hold on. There, it's bigger on that one. That's the picture that it was based on. Sold on a Monday. 4 children for sale. Inquire within. It's another one that is the Paris one is called The Paris Wife. The Paris Wife. So good. So the 4 children for sale picture is what inspired Sold on a Monday. So there's it's Great Depression times, And there's this is the book, not the actual picture. We'll get to that in a minute. But there's a journalist who's driving down the road, and or maybe he's a photographer. It's been a while. It's something about a newspaper. I can't remember if he's the photographer or what. Anyway, he's a reporter in some capacity. He is riding down the road and sees. I'm trying to remember exactly how it happens. Like, I think he sees that that sign, the 4 children for sale, inquire within, and he. Gosh, I'm trying to remember. I'm mixing up the actual story and the real story, but I think he's driving by and he takes a picture of the kids or something. Hold on, let me look it up because I'm getting the real story behind the picture and the book mixed up. Let's see. Because I remember the picture was from an actual newspaper. So Monday. All right, here we go. 2 children for sale. In the book it was 2. The real picture was 4. The sign is a last resort. It sits on a farmhouse porch in 1931, but could be found anywhere in an era of bread lines, bank runs, and broken dreams. It could have been written by any mother facing impossible choices. For struggling reporter Ellis Reed, the gut-wrenching scene evokes memories of his family's dark past. He snaps a photograph of the children, not meant for publication, but when it leads to his big break, the consequences are more devastating than he ever imagined. At the paper, Lillian Palmer is haunted by her role in all that happened. She is far too familiar with the heartbreak of children deemed unwanted. As the bonds of motherhood are tested, she and Ellis must decide how much they are willing to risk to mend a fractured family. Inspired by an actual newspaper photograph that stunned the nation, Sold on a Monday is a powerful novel of love, redemption, and the unexpected paths that bring us home. So, let me find the picture. The actual picture. Okay, the actual picture first appeared in 1948, and a brief caption claimed to exhibit the desperation of a family in Chicago. And then the writer said, as a mom myself, I wondered what could have possibly pushed a parent to that point. In the direst of times, I could fathom perhaps having to give up my children for the sake of their well-being. But why on earth ask for money in return? Possible answers to that question soon became the foundation of Sold on a Monday. So that's how it was inspired. Oh, gosh. So sad. Hello, Michelle. I just ordered Before We Were Yours. Haven't read a good... You'll have to let me know how you like it. Before We Were Yours is one of my favorites. One of my favorites. Hello, Breezy. Hello, hello. Before We Were Yours is incredible. Sold on a Monday is incredible. I love a good book. I get excited about good books. I love reading. I will sit there and get lost in books. And the movies are never as good as the books. Ever. Where the Crawdads Sing is an amazing book and movie. The book, yeah. Actually, I did like that movie. I did. Obviously, I always like the book better. But I did like that movie. That one did the book some justice. I think that the only... there you go. Before We Were Yours is sitting on my desk looking at me now, waiting to be read on vacation. You won't regret it. It is so good. Where the Crawdads Sing is a good movie. It is. You know, I think the only movie, there's two. There are two movies that I have liked as much as the books. And that's Gone with the Wind. That was my favorite movie growing up because I just loved their big dresses. I thought their big dresses were so pretty. And I was obsessed with that movie. Like, I had Scarlett O'Hara everything. I still have a copy of the original 1939 newspaper from when it came out. I loved that movie so much growing up because of, like, I originally started loving it because, you know, it was Georgia, which is where I'm from, where I lived, and it was, you know, big pretty dresses and the, you know, house that the 12 Oaks looked like my grandmother's house with, you know, the big white columns and stuff. I loved that as a kid. And then as I got older and understood more of what the history behind it was and all of that, then I read the book. So I actually saw the movie before that one because I saw the movie since I was little. Loved that one. The other one that I loved, movie that I loved as much as the book, was White Oleander. White Oleander is one of the few movies, I say one of the two movies that I liked as much as the book. It's the only time it's ever happened. And that's because I feel like they nailed that casting so much and they kept it pretty true to the book. Yeah, White Oleander. That one's a really good one. Really good one. It's making me want to go back and reread some of these now. Yeah, loved White Oleander, both the book and the movie. One of the only ones, right? I am not usually a fan of the movies after I've seen the books. I always feel like I have to see them anyway just to see. But there's so many times where they change the characters. And I'm like, and once you spend so much time reading a book and you fall in love with the characters, then when you go to a movie and you see them change, you get mad because you're like, that's not who he is, or that's not who she is, or, you know, I don't like it. I don't like it when they try to Hollywood it. Secret Life of Bees book and movie was really good. I've never saw that movie. I don't think. The Green Mile, you're right. The Green Mile that movie was good too. It was. Fifty Shades of Grey. You know, a bunch of people back home when those books came out, a bunch of people who a lot of people that don't normally get into books the way I did were actually reading that. So I gave it a shot. I didn't like them. I didn't make it very far in that one at all. I made it through the first couple chapters and then couldn't do anymore. Joyful gifted 5 memberships. Thank you, thank you, thank you. I appreciate it. Welcome to our new members. You look good in green. Thank you, thank you. We have just gone off the rails. Did not talk about anything we were meant to talk about. And that's okay. Gone Girl. Gone Girl? That was a good movie. That book, though, whew. The movie was great. The book, whew. That was one of the first, like, I don't know, one of the first. It was one of my main, like, shocking twist books that I was like, holy crap, Gone Girl was really good. And the movie was good. The movie was good. But that book, man, whoo. I'm going to get fired from my job. I've read every book you've mentioned so far. Karen has court today at 2 o'clock Eastern. So I have the schedule, the stream starting at 1:30 Eastern. Deline M. I don't know. Mama, are you still in here? Mama, if you're still in here, look, she has your name. Spelled the same and everything. Never happens. Never. I don't know that I've ever seen. It. Let me close out of, oops, just messed that up. I think it might be starting soon. Sarah Boone. I'm watching. Okay. Hello, that's okay. You haven't missed anything. We've just been chatting about books because we were waiting on Sarah Boone. I love The Notebook. Yes, one of the very few romance type books I ever liked. Will my husband enjoy it if we do audiobook for a road trip? Yes. Yes. It's really good. It's really good. It's so good.
Boone case. All right, she's going to be back in.
Oh. Killer of the Flower Moon. That one's good too. Didn't they make a movie of that one too? See, Mama, she's got your name. Why?
Patricia Cashman on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st.
What happened?
And that was mailed to you at the same address. We've been addressing P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was sent that for?
Notice of delivery of digital copies
What
of
the heck?
documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so
Okay.
for receipt.
Hold on,
And
I'm having
the
trouble
last
pulling up
was a
the.
certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the P.O. Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things reportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you have questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to P.O. Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 20th.
Hold on. It's not letting me do the full picture for some reason. Hold on, let's try. More tech problems.
This morning, ma'am, the court has not filed anything other than what I've identified since that June 28th order, where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing.
He said that is not correct.
A couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do. All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner, Prison Break Investigations.
The one that's, it shows that we're live, but that Prison Break and all this was the other day. Hold on. Because this is showing, oh, oops.
The exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions.
I can't get it full.
And a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right.
Yeah, it's sunny, so it's today, but
Witness and exhibit list.
I can't get the full.
Is included on that USB. Do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good.
As well.
Deputy Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
What the heck? Yes. I can't get it any bigger. I don't know why.
The state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses in trial. I don't have an order or...
It wouldn't be an order. It would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Cacciatore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes. On the USB drives for the laptop, it's not compatible with the USB drives for some of the files, so I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know. I moved on from that to try to go to other programs, so I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me, and that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you, so you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
Okay, all right. Dave?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find the VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio-only files.
Okay, all right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
She wants to know if Geek Squad makes
Mr. Lane.
calls to the jail.
So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State anything else?
All right, we're going to get in a break. We'll hit the pause button on what's happening inside of that courtroom. Remember, she's also asking
Why?
for copies of all of these documents.
Why are we
She doesn't want to
pausing?
just
Let's see. I don't think there's any way around the pausing either. This is going to be oh my gosh, this trial is going to be wild, y'all. This trial is going to be wild. I know, that's why I'm not a big fan of Court TV. Oh, is my microphone too loud? I was recording the podcast. Every time I record the podcast and then start doing this, everybody says my mic is louder. Let me know if that's better. This is going to be the longest trial ever, I feel like, because it's going to be constantly her on the struggle bus. Like right now, like she needs Geek Squad to make house calls to the jail. Oh gosh, it's going to be like, but you know what? She shouldn't have gone through 8 lawyers. I know what she's talking about though. Sometimes files have to be converted. This might have been why a lawyer would have been the better, more brighter idea. Yeah. Even the, when we watched the hearing on Monday, the prosecutor said that they were having to do something on their software in order to be able to view the files. So, I mean, I don't know how this is going to be. It's scheduled for October. It's supposed to be happening in October. And it's going to be, oh my gosh, it's going to be such a mess. No one wants to represent her though. But also, she's doing court-appointed attorneys, which means that she's kind of abusing the system by going through so many and getting rid of so many. So I can understand why the judge is finally like, no, you're not, we're not going to keep on going through this for you when you've gone through 8. I can't remember how many Thami went through. Thami went through a whole heap of attorneys too. Kathy says, I think she'll get a continuance. I've thought about that because with her having all of these issues, oh my gosh, all the issues, it's going to be a hot mess express. Thami went through 9. I knew Thami went through a whole heap of them. I can't wait to hear the judge say sustained. Browns? Unfortunately, it will probably be continued, in my opinion, which is insane. I don't know how she doesn't know anything about the law other than what she's learned from her 5011 attorneys. But dang, y'all, I don't know how she could. Oh my gosh, it's going to be a mess. But I'm going to go. I want to go. I don't know how long it's going to end up taking, but I'm going to go. But Orlando's like a 5-hour drive for me. So I'll have to go and maybe stay through the week. Sarah Boone, Esquire, is going to ask for a continuance. Lord of mercy. Yeah, I want to go. I'm going in real life. I can't not. I mean, even with it being a 5-hour drive, how can you miss this one? It's going to be... Wow. You know, the judge did a woosah before he got on the bench. I'll say this judge was really, really patient with her the other day. Way more patient than I would be able to be. And sometime between now and October, when this trial actually happens, I'm going to have to learn to fix my face. That's one thing I did not do very well when I went to the Charlie Adelson trial. And you can see, anytime the camera caught me,
Anything else we need to talk about with regard to that
can't
issue?
fix my face.
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? Oh, about approximately what time are you going to be meeting with her, if you know?
9 a.m.
Okay, all right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can, yes.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this, State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
We're going to hit the pause button because we are about to reach the top of the hour. Small win there inside of the courtroom for Sarah Boone.
I can't stand the commercials. I can't stand the commercials. I can't stand the commercials. Okay, so the motions that she filed, we got on our book club this morning and didn't actually talk about the motions. She mentioned them on Monday, the ones that were filed. She mentioned on Monday that she wanted to make a note to the judge that she was going to be filing some motions. The ones that she filed were the address one. We talked about that earlier before we got on our book club. And then, let's see, motion for immediate address, mailing address, correction, formal address correction, motion for defendant's reasonable freedom and movement. So for that one, she wanted to request to be unshackled when she's in there. Remember on Monday when we were watching and she was cuffed and she was trying to make her notes with her cuff, her handcuffed hands, and it kind of, she was struggling with it, I guess. They want to, or she wants them to consider unshackling her and uncuffing her when she's going in there for all of this so that she can move around easier. So that's what that one is. Let's see what else. Oops, it locked me out. Sarah Boone. I'm not a robot. Yeah, that's the freedom of motion one.
More ahead here on Court.
More ahead. Whatever. I hate commercials. All right. Motion for defendant's reasonable freedom of movement. And then the other one is the motion for defendant to lawfully receive, review, utilize the original hard copies, etc. So, and all of these are like, all of these are handwritten. All of her handwritten, which is crazy. My finger will be cramping. Discovery, definition, exploration, or examination, finding something out by search, observation, process through which attorneys acquire evidence in a case and encompasses practically everything an attorney may or need do under the rules of criminal procedure to acquire evidence for trial. Imagine how frustrating it would be to have to try to read all of her handwriting while you're doing all of this. Some of her handwriting is actually pretty nice. The one that I have on the thumbnail of her little flyer to look for look for an attorney? Her wanted ad? That one's not too bad. So the evidence control sheet states A, box of discovery, B, box of discovery. The court will reach out to the jail to inquire how to deliver the defendant and will provide written order to release both boxes. So remember on Monday, they were asking too in her, like she doesn't have, it's not like she has a office for herself at the jail. She has one drawer, and they said that having her stuff sent to her kind of opens it up for other people to be able to get their hands on the discovery or whatever, because she only has one little drawer where she can actually keep stuff. It is a terrible idea to represent yourself when you're in jail. It is a terrible idea. Terrible idea. Laura, thank you for the super chat. Devil in the White City. Eric Larson about Chicago's World's Fair. About H.H. Oh, H.H. Holmes. That's interesting. And David Burnham. To Die For. Excellent. I'll have to read that one. We should start having book clubs every week or every other week or something. Add one more thing to my busy schedule. But I love it. Thank you. Thank you for the super chat and thank you for the book recommendations. Let me write it down. Devil in the White City. Devil in the White City. I always love a good book. Laura Elizabeth, thank you for being such a blessed woman. Thank you. Thank you, Lauren Elizabeth. Thank you so much. I appreciate it. I appreciate it. Kate says, at the same time, this is all in the taxpayer's dime. I think that's why they stopped wanting to indulge her with all of these different attorneys. It's like she's prolonging the entire process and costing a lot of money in the process. Oh my gosh, it's gonna be a mess. Watching this trial is going to be a mess. Oh, what happened? Stop pressing buttons, Brandi. There we go.
Matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand-filed with the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay. So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that?
That's interesting.
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay. All right. Let's go ahead and call your witness. State.
State will call Gavin Lowton.
That's interesting.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LLWTAN.
All right. Thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
court security.
And how long have you worked that assignment?
Over 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge of the defendant.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings, or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Lowden?
I do.
Go ahead.
First off, in your, in quotes, research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Object to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask 1 fact per question.
Okay.
I am prepared to give her the date. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, whatever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in court?
At the jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
For the September 15, 2023, it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay?
Second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, G-R-E-E-N-E.
And what was the first initial, please?
K.
G-R-E-E-N-E.
Yes.
10/16/23.
Yes.
Okay?
And the third one is January 28, 2021. And the officer is Jasmine Scribner. S-C-R-I-B-N-E-R.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward of the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay? And January 28th?
At approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay. So I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
I'm going to sustain the objection.
So the domestic violence, the original, was dropped. I was never charged with that.
I'm going to object as to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact, or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
Oh boy.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me, because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently, So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that isn't your history.
I understand, but I was never charged with it, correct?
You were charged.
We are hitting the pause button on the pretrial hearing, and we're going to bring in trial attorney Krista Rain.
Y'all, y'all. Let's do a poll. Let's do a poll because I saw somebody ask the question, is she going to be the next? Is she going to be as bad as Daryl Brooks? So let's do a poll. Okay, will she be the next Daryl Brooks? So your options are she will be worse, she won't be as bad, or about the same and they should just be pen pals. Those are your three options. So I just put up the poll. This is like a little bit of a glimpse into how this is going to be. Oh boy. Oh boy. She said, first off, okay. Yes, ma'am. All right. Okay. All right. Oh my goodness gracious. I got to learn to fix my face before trial starts. I feel like she's going to be just really argumentative because she gets mad and she gets her sassy pants on, her sassy shackles. Too soon. First off, those charges were dropped. Oh my gosh, this is going to be interesting. This is going to be interesting. There isn't enough paper in the prison for them to be pen pals.
Justice.
Join Court TV's Vinny Pal.
Gosh, I hate commercials. I wish they were showing this somewhere else. Ow. Just pulled a sand spur off my britches. She don't take no for an answer. Worse, she's calculative. Daryl was impulsive. She's so argumentative, too. Grounds? This case is going to take forever. That's what I'm worried about because she keeps saying, like, I don't know what I'm doing. Can she file an appeal based on ineffective counsel? No. Oh my gosh, it's going to be a disaster, y'all. But also incredibly interesting. Incredibly interesting. I can't fix my face, so I wear a mask. Sarah's entertaining, but I don't think she'll be the same meme generating machine Daryl Brooks was. That's a high bar to meet. I just feel like when it comes to, because keep in mind, here's the thing. Right now, she is only arguing with the judge, and then this is like a small sample of what we might see with her with, because she's going to be doing cross-examinations and stuff on these people. And so I feel like she's not going to talk to the judge as sassy as she does to the other people. She's going to get, I feel like she's going to get like, oh gosh. She's going to be hostile. Yeah, she's going to be a hostile defendant. Oh my gosh. Carla says, how will judge stop her from telling the jury she is pro se against her will? How likely do you think it is that this is going to end in a mistrial because of something that she does? And then have to go through all of this again? I mean, I could see that happening. Well, her counsel is totally ineffective. More defective. I feel like she's going to be getting into a lot of trouble with her questions in court. I agree. There's going to be so many objections. We're going to have to do an objection counter. Goodness gracious. It might be one of the quickest verdicts we've seen. I think the quickest that we've seen since I've been streaming is the Richard Merritt. That one was under an hour. Oh, good. I didn't see your feelings on your face during Adelson. You were better than you thought. Good. Most of the time, too, I was staring at the jury because I was very focused on their reactions to everything. Wait until her ex takes the stand. Oh, my goodness. Aunt H says, I don't think it will end in a mistrial. It might not, but man, she's... I don't know that she has the self-control to be able to avoid it. I feel like it's going to be a long trial because of...
I understand that I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The arrest is on your record.
But the charge for the domestic violence is not on my record.
No, you were never
Just
convicted.
to ask and answer, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department, so I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it a...
Your Honor, I'm going to object to the form of the question. This is a statement, not a question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question.
Thank you.
In the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object as to has to be answered.
Sustained.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Okay. Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraints.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024.
Oh my God.
Okay. And you're going solely off of what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped. Doesn't mean it didn't happen.
Okay.
Oh my God.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is.
And you can still apply it even though it's not been.
Correct. It's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-up, Steve?
No, Your Honor.
Fine. Thank you, sir. Okay. Anything else, Steve?
Nothing to say.
Okay.
Oh.
I see Deputy Barnett here. Could you come up, sir?
It's gonna take a while.
Looks like the judge wants to address some things with his clerk and another witness on the stand. We'll hit the pause button and get you back into court in just a moment.
I can't stand the commercials. She does, if you read her motions that she's filed and stuff, look, is she a whack job, as Proctor would say? Okay, perhaps. But she does know more about the law than she's saying. She says that she doesn't know what sustained means, but if you've read her handwritten motions and letters to the judge and stuff, she knows more about it than what she's saying. Oh my gosh, this is going to be oh my gosh. Why am I laughing at her? I am laughing at the ridiculousness of all of this mess. Oh. For whom is this act she's putting? I feel like because keep in mind, she said to the judge on Monday when we were watching, and I think she said it today too, didn't she? Or else I'm just batshit crazy. But I think that she said today too, she said that she doesn't want to be pro se. She wants an attorney. So I think that she is potentially playing it up a little bit to make it, and I'm not saying that she knows, I'm definitely not saying that she knows enough about herself, like knows enough about the law to represent herself. Definitely not saying that. But I think asking what sustained means, I think that was an act. I think that she's potentially playing it up a little bit because she said that she doesn't want to represent herself, that she doesn't want to be pro se, that she's being forced to. Karen Reed hearing is at 2 p.m. Eastern. So we will be live at 1:30. Thank you for the super chat. Hi all, this is going to be a train wreck. We will all be watching. Yeah. It will be. Definitely a train wreck. And tell us, the jury selection starts Monday, so we're gonna watch that one. That one will be starting about the time that the one that we're doing now, the triple homicide retrial, it'll be starting about the time that this one ends. It may, depending on when they get the jury seated, that one's going to be the next one that we're doing. She fired 7 attorneys. I thought it was 8. Is it 7? How sorry do you think she is that her boyfriend suffocated to death? The video is crazy, though, because she's like 0 F's given. She is just sitting there with her glass of wine, laughing at him, telling him he shouldn't have cheated and he shouldn't have done this or that. And he's saying he can't breathe, and she's just recording it. Just recording it. Crazy. Setting up for an appeal. I'm curious to see. Oh, let's end our poll. See what the poll results were. Okay, so 46% of you think that she will be worse than Daryl Brooks. 27% said about the same and they should be pen pals, and 26% said not quite as bad. You look like you're rethinking your life choices. Watching Sarah Boone can make a person do that. Yeah.
When did you do CPR? This morning, when I found it. Before you called? Yes!
Forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
I don't even. Yeah, only ankle restraints during trial, which is, that's not. How many people think she's going to have at least one outburst during trial? I feel like she will. I don't know how she wouldn't. Seeing kind of how her lack of self-control is.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Chad Hornet.
And not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the Deputy Sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There's a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment is at a level 3.
And what is a level 3?
Level 3 would be fail to follow the directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
All right, ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We can take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you will have to re-sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken it off?
No.
And it's a very simple process to apply?
Yes.
And remove?
Yes.
Thank you.
Any follow-up?
Nothing to say. All right.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg irons, your hands would be completely free. The stun cuff, same thing.
And then and I would be able to walk?
You would be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
Thank you, sir. State any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option?
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read.
Over and over and over
So
again.
if you would like to clarify me for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
go ahead.
it's just handcuffs means unhandcuffed, And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that, again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
We're hitting the pause button on this testimony. We do have to get to a break. Let's bring back in trial.
The breaks drive me nuts. So her motion did say unshackled multiple times. So now she's, I guess, saying, I don't know what she's saying. She keeps going back and forth. She doesn't even know her own motion. This trial is going to last for years. If this is, I mean, 11 years. Yeah, Sarah says this is all, she blames everybody for everything. It's, yeah, the judge's fault, media's fault, ex's fault, attorney's fault, everything. Eating my hair. Everything is everybody else's fault, and she doesn't do anything wrong. No. Ugh. Eating my hair. No, and it drives me nuts. Planning her escape. Jane Blue says, you are really picking on her. Eh. Kind of opened herself up for that one. I can't wait to, oh my gosh, I didn't even think about this. I'm so busy focused on her cross-examination she's going to be doing. I did not even think about her opening statements. Oh. Gracious love. That one's going to be, and her closing arguments. Yes, Karen Reed, 2 p.m. Eastern. She knows exactly what she's doing. This is how she wears people down until they give in. That makes sense, actually. That makes sense. She made her own bed. No, this hearing is live. We're equal opportunity. We pick on everyone at trial. Everyone's fair game except for the victims and witnesses that don't deserve. But attorneys, judges, and people like that. That's what we do. We discuss what's going on with them and what they're doing. The judge has no idea what he's in for. He's going to need medication by the time he's done with this. My hunch is she will take a plea. But they offered her one originally and she turned it down, right? So she goes in circles that makes you dizzy. She does over and over, and she contradicts herself. And oh gosh, this is exactly what she's going to do during trial. She's going to talk in circles again and try to cause delays. Poor Sarah Boone killed her boyfriend to suffocate, and we are mean to her. Boo-hoo. The thing is, this isn't one of those things where we don't know if she did it. There's video of her laughing, and as he's saying, he can't breathe. So this isn't one of those things where we don't know if it could have been somebody else or what. The fact that she recorded that is... Voir dire will be fascinating. Have you played hide and seek? Do you like crafts? Oh gosh. It's going to be... Oh gosh. Yeah, that video is horrible. I can never unhear him begging her to let him out because he can't breathe. Yeah, she didn't care. She just was like, well, shouldn't have done this, shouldn't have done that, shouldn't have cheated on me. Shouldn't. And she said that he was violent. The domestic violence is his fault. I think she enjoys the attention too, honestly. Yep, laughing as he is literally dying. Crazy. Then she tried to say they were just playing hide and seek. Hide and seek in a suitcase that he couldn't get out of.
Would you also be asking the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial. Okay. Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you were seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Okay, thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and to actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy already identified, Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns, which is part of the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc., and that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder was representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint and whether those alternatives are less prejudicial.
We've reached the top of the hour. We are hitting the pause button. You won't miss a moment, and you won't.
Gosh, the freaking pause button. Do you think that the judge will lose it? I don't know. He's been really patient. He's been really patient. Well, that's the way Judge Darrell was too. You know, if you watch any of the wildness that went on with Darrell Brooks, that judge was very patient. The trial is set right now for October 7th, I think. I have to check my calendar. I'm pretty sure it's October 7th. It just makes me wonder how long it's going to take. Like, how long it's going to take for them to get through all of this. I really hope we get someone other than Court TV. Yeah, Court TV is pull feed goes beyond Court TV. So, or Karen Reed, the pull feed goes beyond Court TV. So we won't have to deal with all this for that. Thank goodness. Oh my gosh. Yeah, pretrial September 26th. And they had, I think, they had a Oh, it signed me out. I was signed in looking at her records earlier. I think they had the evidentiary hearing on the 24th, I think. Or no, evidentiary hearing was on the 3rd. And trial October 7th. She seems very sane compared to Brooks. Okay, but keep in mind, when she gets to the point where she's doing cross-examination and stuff like that, she's going to have her sassy pants on, sassy shackles. After seeing Darrell Brooks' trial, I'm confident they will get through anything she may bring up. Box fort. How long do you think the state's case in chief will be? I don't know. The thing that concerns me is I feel like there's going to be so many sidebars and having to stop midway and send the jury out to discuss stuff, and she's not going to know what's going on, and there's going to be a ton of objections, and it's just going to be a mess. A mess. Three weeks trial starting October 4th. They have it set for October 7th, and then they have the docket scheduled for the weeks of the 7th, 14th, and 21st. So they have 3 weeks set aside for it on the docket. We'll see how long it takes. Oh gosh. Yeah, there's one on August 14th too. I'd be scared out of my mind having to go pro se. Me too. Especially in front of, it would be a lot of pressure. Because you're literally fighting for your life. But, I mean, at the same time, she put herself in this situation, so.
In Florida.
Oh, still. This is the one, the Tao trial. That's the one we've been watching. That one got crazier than I was expecting. Alec Jones is the one that I told you all about, where him and his brother killed their dad, put him in a ditch. Jury selection is going to be, oh gosh, jury selection. When is your next live and what times? I'm a newbie. Welcome, newbie. I am going to be live for the Karen Reed hearing this afternoon. The trial that we've been covering is this one, the Wisconsin versus Nia Tao. And it's a triple homicide where him and his buddy took 3 guys that were 23, 23, and 24. They were big into the drug scene, and they thought that one of them had stolen money, so they took them out to this quarry and made them get on their knees and execution style shot them. One of them took a plea deal, and the one who actually pulled the trigger is on trial.
Given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who was in charge of security. Our concerns are just making sure that she is given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so ma'am, the court's gonna grant your motion and that you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
I agree. That's fair. That's reasonable.
The other item I have on... Yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that.
Yes, sir. Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off
in advance.
She gets up here.
Yeah, I understand that. Okay. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to?
It is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done. Okay. We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address box, for lack of a better word, for where you'd be able to go and not go, and I'm going to give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you can do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself, or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State, anything to clarify?
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report, you were just speaking about regarding them providing me with the laptop each day. What is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate P.O. box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, well, my concern was they're not stating what it was that I looked at for how long and
I don't know that they're going to record that information of the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence.
All right, this Sarah Boone gets one answer to her motions.
The commercials, I can't. Imagine she made a run for it after winning her request to be unshackled. The zapper? Could you imagine being the one in control of the zapper? You know, when we watched the Bryce Avery trial, Bryce Avery is a bad dude. Bad dude. He killed those children, the woman that he was dating, their children, and then he laughed at her in the courtroom and stuff. Bad dude. He's one that had the stun belt on, and I just, all during trial, was just hoping he would act up because I wanted to see him get stunned. He's a terrible, terrible, psychopathic fool. But it's not uncommon. Shabusiness had one too because she attacked her attorney. She had one too. I think hers was the belt kind. Hers wasn't the cuff, if I remember right. This is going to be... I would have loved to see Judge Darrow handle this one as well. She has the patience of a saint. Her opening statements will be 200 pages long and handwritten, and she'll have to flip through. I wonder if she'll be the type that like turns to the jury and tries to address them like they're like this witness is lying. That is not what I said. That is not what happened. I like how he said too, when she asked about that, he was like, well, like I read to you on Monday and gave you the hard copies and sent you a copy. This is what was said. It's like, that was very like per my last email. Brooks had it on. Oops. I almost blocked you instead of showing your comment. Brooks had it on also. It's not unheard of. He was a nasty man. Bryce. Ugh. I just wanted him to get zapped so bad. So bad. Patience of a saint, her hair was God tier. She did have good hair. Imagine Bev with her. Could you imagine? Oh my goodness gracious. Yeah. No, I couldn't imagine that. That would be entertaining for sure, but I could not imagine that, no. I'm still behind, but she got worse arguing her motion to be unshackled. I can't wait for her opening arguments. This is going to be crazy. Yeah. Yeah. It's crazy. I've been so focused, and until Terry said that too, I've been so focused on the cross-examinations. I had not even thought about her insane opening arguments. Oh my God. Or opening statements. Who would be the judge you would like to see her with? That would be the most entertaining with her. I canceled a doctor's appointment in order to not miss a minute of trial. That's funny. There's a part of me that wants to see her zap, but I have to pinch myself, and I have to pinch and remind myself this isn't gladiator style Coliseum amusement. Yeah. I remember, Brandi, you kept saying shock him. I did. I wanted him. He was such a terrible person. And then to laugh at that mother in court who he killed her babies in such a brutal, horrific way. And then he laughs at her and blows her a kiss. I wanted him to get shocked so bad. A guy named Kevin. Oof. Where do people get that she was ever offered a plea deal? I discussed it on Reddit, and I'm pretty sure it's a rumor. It's an urban source rumor. I haven't heard of a plea deal. Somebody was saying it earlier that she was offered 10 years. I haven't heard of a plea deal. I think she should have taken one if she was offered one, but I have not. I don't know of one. Judge Boyd, Judge Bev. Dara would be so patient with her, though. Judge Judy. Judge Simpson. Borowski. Bev and her interacting would be funny because, yeah, that one would be funny. Bev has about this much patience, and this heifer requires a lot of patience. So that one would be interesting. What was the name of Chaco? Bryce Avery. And he pled not guilty by reason of insanity, I think. You caught that? I didn't. I try to catch myself. Judge Cedric Simpson. Oh, the talk about the plea deal was the other day. The state said they may offer it later. So that's all. I don't know of anyone that has been offered in the past, but the talk about having one. If she is offered one, she needs to take it. Because Lord knows she ain't gonna be. Oh my goodness, I would love to see this judge or this woman face the male judge who did the Rittenhouse trial. He did the Zachariah Anderson one too. Shoot, why can't I think of his name? Schroeder. He's the one that during the Zachariah Anderson trial, I think it was the Zachariah Anderson trial, he like pulled out an orange out of his robe and was like, oh, an orange. Like, ugh. He was entertaining. Hello. I'm very late. I'm gonna have to try to catch up. Well, the whole first part of the stream is just impromptu book club because I didn't take my ADHD medication and we got off topic.
Welcome back to Court TV Live. I'm
Warner from Show Business. Judge Schroeder would be interesting with him because he was like, you're not allowed to. He got mad at one of them for saying a cuss word.
but she'll be able to.
He's like, not in my court. For crumb's sake. Oh my gosh, I forgot about that. For crumb's sake, that was Schroeder. That was hilarious. So funny.
We did discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning, and that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at Courtroom 12A, Orange County Courthouse, and then the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question, though, was, are you still trying to decide or research having the media here?
Yes, ma'am. I've pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence, and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems. The Miami Herald decision, I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the evidence from the state?
The digital evidence only.
Of the 2 USB drives from Mr. Lane?
Oh, no, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in an order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This is the letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a Word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, you can give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain Di Giovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please. In regards to the media, being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence view, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of the mail. It was already mailed? Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy and provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
Okay, Sarah Boone, defendant, and she's a pro se defendant. She's
Well, bottle of bourbon waiting in chambers. Yes. Dog Mom, happy 14-month memberversary. 14 whole months. It's over now. I can do my chores. Whew. Yeah, 8:14 at 1:30. And then we have the one that she doesn't want the media for is the evidentiary hearing. So that one is on September 3rd. And all that one is them going over the evidence, which is why she doesn't want the media at that one. But the media will be at all of the other ones. That's already been approved. So but she doesn't want the media at the evidentiary hearing one. And then September 26th, I think, is the pretrial, and then October 7th is when the trial starts. Somebody mentioned the phone. So the phone at the last hearing that we watched on Monday, that one was interesting, to say the least. She asked about her phone, and they said that they were going to give her the printouts of the Celebrite and stuff like that, and the information from the phone. And she asked if she was able to get her phone and actually flip through it, and if she'd be able to look around. Like, she's wanting to check her Facebook notifications and whatever. She wanted, and they were like, no, that's not how that works. You'll get the printout of all the data. Oh, goodness gracious. She is mad about that being brought up. She wanted to know the names of who said it. She wanted to know what they said. Names, dates, and he had his receipts. He was ready. Seething about that 2018 arrest. She said those charges were dropped. She wants internet so she can watch here the comments and get free advice. She mentions media a lot. She mentioned on the one Monday too that her jail calls had been released. I have not heard any of her jail calls. And I meant to do a FOIA and I forgot, but I can put that on my list. I can put that on my list too. Because I have not heard any of the jail calls. She's about to write a very strongly worded letter to someone's manager about removing all negativity from her record. Yeah. For real. Oh gosh. That's how she was on Monday. She was like frustrated with the judge, and it was very much like, let me speak to your manager. She's like, I don't want to represent myself. You are making me represent myself. Ma'am, no. You have gone through 8 attorneys, and this is the consequences of your actions. She wants to do all kinds of things that are not allowed and unethical. That's what the lawyer said, which is going to make how she represents herself even more interesting. What was this 2018 domestic charge? She was apparently charged with some kind of domestic violence, but the charges were dropped, and the fellow who was up there talking about it said that that could have been because the people didn't want to cooperate, not because it didn't happen. And look, I get it. Innocent unless proven guilty. But at the same time, they have to look at things from a standpoint of, you know, for stuff like that, they have to look at that in totality of, given what she's already done, it's previous charges for domestic violence, which is, this is like the most extreme form of domestic violence, her killing him, allegedly. So, I mean, they have to look at all of that as a whole to decide how they handle this. But, I mean, she's going to be uncuffed. I would love to hear this. Me too. Me too. I'll have to FOIA and find out. I'll do that when we finish here, because we got a little bit of time. We got 2 hours before we start on Karen Reed. So I was going to work on the podcast, but I'll do that during my 2 hours too. Crazy. We're choking. Yeah, didn't he say there were previous domestic threats of battery by strangulation? Demand to speak to your manager. She wants to speak to the judge's manager immediately. I really do want to know if she missed court. She was probably irritated that they woke her up at 2 a.m. to tell her, but did go. Well, that's the thing is, they have, some of the jails will, because they have to transport you to court and all of that, and it's like a whole process. And so they'll wake them up at like 3 a.m. You have an hour to get showered, get ready, whatever. Then you have to go through the whole process of going out to the van or whatever takes you, and then you have to go, you get to the court, and then there's a whole process once you get to the court and all of that. So I remember them talking about this during, was it Murdoch or something, one of those trials, where they were talking about how long that process actually takes. So if the hearings are starting at 8:30 a.m., I mean, 5 hours, waking her up 5 hours ahead of time seems excessive, but when you think about how long that process apparently takes, and they said it's like a lot of hurry up and wait, hurry up and wait. So I guess maybe that's why. Zach in here causing trouble again. My favorite mediocre streamer. Thank you, Zach. Kind of, thank you. The 2018 police body cam footage is online. You can clearly see bruising on his neck. Yeah. Yeah. A van with a cage, like Alec. At the same time, during hearings to remove attorneys, she said that there were hearings that she wasn't aware of. It'd be interesting to see the dates of both. I'll have to make a timeline. Kat Randall, thank you so much for gifting a membership. Thank you. Thank you. Thank you. Thank you. Kathy, welcome. Good to find this channel. It's dinner time for the grandkids here in sunny England. Welcome. Welcome, welcome. A mediocre, thank you. Our favorite mediocre chat member. Love it. Love it. How's she going to have a sidebar? Oh my gosh, she's going to want so many. And they have breakfast at 6 a.m. Sarah Boone is a master manipulator and professional victim. Oh gosh, it's just going to be... I'd be interested to see if the refusal dates line up with the dates that she claims she wasn't informed. Will they be getting her up at 3 a.m. every day for trial? That seems wrong to me. How can she defend herself with hardly any sleep? Can't prep the night before. I mean, these are things that... These are all reasons why she should have maybe thought about how difficult being pro se would be when she was going through the first 8 attorneys. But I'll say this, look, the prosecution and the judge do seem like they're being very fair with her, even given all of the wildness that they're still being very fair with her. When you think about the fact that this woman sat there while he basically suffocated and begged her to let him out, you realize this is a dangerous person. If it wasn't for that video on her phone, it would be... That video on her phone is what's really going to do her in with the jury. Because without that, you could maybe have her argue like, you know, I don't know, we were drunk and goofing around and playing hide and seek, whatever. But that video is what's going to do her in. She's a child every time she makes a mistake. She goes off on a rant arguing that she doesn't know what she's doing and that makes it okay. God forbid if there's a mistrial, what happens? Does she go free? Is there a retrial, and how on earth could they prolong that again? It depends on what the mistrial would be for. So there are some mistrials that if they declare a mistrial, then you can't go through the process again. Like, for example, Alec Baldwin. Stuff like that is if there's prosecutorial misconduct, judicial misconduct, things like that. If there's a mistrial for something that is not the court's fault or prosecutor's fault or something like that, if it's like a hung jury or if it's something that is said or comes out in trial that prejudices the jury, that you know, they think it's too much, too far, you can't unring that bell, or things like that, you would be able to go back and retry for. She's had 5 years to realize how much goes into this, and she was warned. She expects her attorney to spend 24/7 on her case only. The one attorney said she was calling him 5 to 10 times a day from jail alone. 5 to 10 times a day. Let's see. Karen Reed timeline. The time Marino states Karen and John were on Cedar Crest or whatever road climbing stairs. Doesn't the Nagel's tests conflict with that? Texts? Yeah. Lally's explanation for that was that he could have been texting that as he was turning on the road or something. That was his Lally-splaining. Lally-splaining. Are we watching the trial next? We are going to watch, we've got 2 hours until the Karen Reed hearing. So we're going to take a break now, and then I'll be back for Karen Reed. And then depending on how long that lasts, we may watch, we'll see how much of the trial we can watch today. It all depends on Karen Reed. If not, then we'll watch some of the trial from today on Monday while tell us. Actually, let's see who has let's see who's testified already today. Because y'all know I want to see, oops, I just hit my microphone. I want to see Blackie / Peacemaker / Ratnasack / Ratatouille. Let's see, it looks like they go over text. So far, that's it. This trial, the reason we have to speed trial this one, they go so slow in this one, and they talk so slow. So we have to speed trial this one because it's too slow. So far, they've only had the one witness on there, and it goes through texts. So we'll see about doing that one after Karen Reed, depending on how long Karen Reed takes. I was on a jury with a pro se defendant, and I hated it. The judge had to explain all the time. It's going to be really long because of that, I feel. Yeah, if it's dismissed with prejudice, that's when there's no retrial. And that's for the things like the prosecutorial misconduct and stuff like that. She's been given lots of accommodations over the years. It will never end. Yeah. Yeah. Five times a day, and she complained she couldn't get witnesses with the phone time she's allotted. That happens to a lot of people here for some reason. There are people that will have to come in and re-subscribe every so often. Some of them really often. No idea why. Two hours of beach cam, not saying, just saying. Beach and panda cam, my two favorites. Okay, I thought I'm way more behind than I thought. Thank you for the super chat. I actually wrote her a letter and shared my opinion that if she just admits she's an alcoholic who is blackout drunk and apologized, she might receive some compassion. I know she would from me. I feel like if there had ever been any moment where she showed some kind of remorse or empathy or just a little slice of being human, that it would be a lot easier to be forgiving-ish. But, or at least more empathetic, but man. Man. All right. I am, Streamlabs thinks that you're posting links if you have a period after a sentence and then you don't have a space after the period, it, for whatever reason, thinks that you're posting links. So it's annoying. All right. So we're going to wrap up for today for now. I'll be back in an hour and 45 minutes for, I was about to say Sarah Reed. Nope. Karen Reed. And we will watch that train wreck. I don't think that it's going to be shocker. I don't think that Bev's going to be like, oh, okay, yeah, we'll just dismiss these. But I am very interested to hear the arguments on it. That's what I'm really excited to hear. There have been the jurors who have reached out. Of course, we heard recently that Juror B personally reached out, so that one's no longer hearsay. So I'll be really interested to hear the arguments on that. I expect Lally to totally be Lally. I expect Bev to totally be Bev, but I really want to hear their arguments on this and see how it goes. It'll be interesting. Let's see. Thank you for the super chat. Did Karen call her father from jail and tell him she hit something at 34? I'm debating someone and do not remember that part. He said in an interview that she told him that she hit something, but it wasn't a call from jail. The problem is that she doesn't seem drunk in the video. Bev will be at the Cape by 3. Denied. Did you all see that someone filed a complaint to the bar for AJ? Hilarious. People are ridiculous. People are ridiculous. They've been like trying to contact my family. Somebody somehow found my brother's phone number. My brother who lives out of state. We don't even live in the same state. We live 12, 13 hours apart. And somebody found his phone number thinking it was me and sent him horrible, horrible text messages. Reaching out to my family and friends on Facebook and stuff. People are psycho. His first initial is the same as mine. His first initial is B. So they found a B Churchwell listing somehow and thought it was me. I was like, I'm so sorry that happened. I was like, well, what did you say? He said, I told him to fuck off. Sorry for my language. People are crazy. People are crazy. Yeah, it's getting out of control. It's been out of control. All right. So let's wrap up now. I've got to get a few things done in the next hour and a half, hour and 40 minutes. Spicy Brandi. Yeah, look, you start involving my family with your nonsense, then I will ask the good Lord to come back inside of me, but I just cannot guarantee it. Compton Brandi starts coming out. The hearing starts at 2 Eastern, so we are going to be back at 1:30. I've got this set up to where it will automatically portal you over there so you can hit notify me and all of that good stuff. So we're going to start about half an hour early so we can watch all of the craziness and talk about what they're going to be doing and all that. We'll watch some of the stuff going on outside, all that good stuff. Thank you. 12 Gauge Investigative. Thank you for super chat. New to your channel, fellow creator in true crime. Welcome. Thank you for checking me out. I'll have to check you out too. Welcome. All right. Let's see. All right, I'm going to end this. All right, I will see y'all in about, let's see, oops, there we go. I will see y'all in about an hour and a half. So, see you soon.
Yeah, I gotta go. I can't stick around here forever.
It was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel. And
Goodbye. How the heck do I get out of here?